They don't answer me anymore.
Caroline, could you tell Norma to call maintenance? I will send an email.
Okay.
So I'll do that as well.
And they came in when nobody was here.
Mhm.
Ready, Judge?
Okay, just a second. Hey, all right, we're starting. Okay, bye-bye. Excuse me, on this election for punishment, the defendant has not signed it, Mr. Young. And my understanding, the range of punishment in this case is 2 to 10 years or potentially minimum 25. Is that correct?
Yes, Judge.
All right. So, Mr. Salinas, are you ready to proceed?
Oh, it is not.
Okay. All right, let's bring the jurors in.
First stroke play at the end, there's a number on the seat that is number 7, the number 8 in the second number on top. You're at the end of the. And there's a jury sticker. 30 and 30.
right, everyone, please be seated. All right, everyone, good afternoon. Good afternoon. Am I not in the South where people don't respond? Good afternoon, everyone. All right, so make sure your shades are off. The heads, you're in court. All right, I'm Stephanie Boyd. I'm judge of the 187th District Court, which is where you are. You're on the 4th floor. You're in the 187th District Court. So everyone, which court are you in? 187. Which floor? 4. And who's the judge? Okay, that trailed off. So I'm Judge Stephanie Boyd of the 187th District Court. So which court is everyone in? 187. Which floor? 4. And who's the judge? All right, so that woke everyone up. And the reason why I asked you all that, I asked every panel who comes in that, is because sometimes people get lost at the courthouse. One time we were looking for a juror, we could not find them. And we discovered that they were down the hallway going to sit on another jury panel because they had forgot they were in the 187th. So that's why I always say that all the time. All right, so everyone, you have in your possession something that's extremely expensive. They're cards with numbers on them. So is everyone able to raise those cards up? Awesome. So whenever there's something you need to say, or you need to address a question, or there's something that comes up that pertains to you, I'm going to ask that you raise that card before answering. And this is the reason why I do that. To my right, we have Brenda DeMoss. She's the court reporter here. Excellent court reporter. I think she's the best in the courthouse. And I think she can take down 3 people at once. I've seen her do it before, all the while texting and baking cookies. But we don't want to make her job super hard for her on a Tuesday. This is a great Tuesday. It's not a Monday. And she really can only take down 1 person speaking at a time. So if everyone can remember, only 1 person speaking at a time. And the person that we have here to my right, she is actually someone who's going to become a court reporter. So she's going to be with us maybe throughout this trial to just see how things are going, because court reporters, they have to have practical hours where they're actually viewing and taking notes. So the transcript that's being taken down, that's the official transcript, will be the transcript that Brenda is doing. So we're not going to speak too fast because we want the person who's going to become a court reporter to know that it's such a great profession and it's not difficult. All right. All right, so I've introduced myself to you, and I want to give the parties in this case a chance to introduce themselves to you as well. So this case is the state of Texas versus Anthony Salinas. If I could have parties of the state, please introduce yourself.
Good afternoon, everybody. My name is Michael Hill.
Good afternoon, I'm Michelle Hayden.
And for the defense,
Well, my name is John Young. I represent Anthony Salinas.
all right, you can have a seat. Does anyone in here recognize any of the parties who just been introduced to you? If you recognize anyone, just raise your card. All right, number 24. Oh, just 1 moment.
Well, could I ask, did any of the jurors beyond the first row stand?
Oh, John, I'm getting there. Trust me, there's a process. So everyone, it's very important that the court reporter hears you, that I hear you, that attorneys for the state and attorneys for the defense hear you. So I always say this is the rule and people forget this rule. So I want this to be the jurors that remember this rule. If you're in the jury box and you have a question that's asked of you or you want to say something, you can remain seated. If you're on this front row and you have something to say, you can remain seated. Everybody else, when you speak, I'm going to need you to stand up if you can. The reason why is because the sound in this room doesn't carry very well and Brenna won't be able to hear you. So is everyone able to do that?
Yes.
So juror number 24. You said that you recognize someone?
Yes, Mike Duriel and yourself. I think I might follow you on social media.
Oh, hello.
And I'm a voter, so I've seen y'all on that.
All right, thank you. All right, I'm going to speak to you all first, and then after I finish speaking to you, I'm going to turn it over to the state and defense to speak to you. All right, so the charge in this case is, well, I'm sorry, before I get to that, do any of the jurors, do you all recognize any of you here today, other than you met for the first time downstairs? Does anyone recognize anyone? Okay, I find that shocking. Usually there's a teacher on here who has a student or coworkers. One time we had the wife and the ex-wife, so that's not here. Okay. All right, so the charge in this case is violation bond or protective order assault. Just want you to think about that, and the state and the defense are going to be asking you questions. Now, all of the questions that are going to be asked of you are hypotheticals. It is not about this specific case. Neither the state or the defense can tell you what they think the facts are in this case. So when they speak to you, it's going to be in hypotheticals about any other case but this one. Does everyone understand? Now, the way someone comes to court for a case where they're charged with and we're getting ready to start a jury trial is through an indictment. Has anybody heard of the word indictment before?
Yes.
Okay. So an indictment is just telling you what you're charged with and where you need to appear. How many people here have had any type of traffic ticket? This is me. No, raise your cards. You guys, you're not passing the test so far. So how many people have had a traffic ticket? If you've had any type of moving violation, raise your card. All right, so some of you have not. I'm proud of you. So when I was growing up and I got a traffic ticket, that's when they would give you the paper ticket. So they'd write out the paper ticket and they hand it to you. Now I think they do it electronically or something. So let's say, hypothetically, your traffic ticket, they're saying that you were speeding or that you ran a stop sign or you didn't follow the yield sign. When they give you that ticket and you accept that ticket, that's not you saying, oh yeah, I didn't stop at the stop sign, or I ran a light, or I was speeding. That's just you accepting that, saying, okay, I understand what you're saying I did. And then you get a chance to go to court. If you want to go to trial for that, you can go to trial for that. Does that everybody understand?
Yes.
So when someone is indicted for an offense, you must not consider it at all for that person's guilt. Does everybody understand that?
Yes, ma'am.
Is there anyone here who's going to hold it against Mr. Salinas because he's been indicted? I'm sorry.
No.
No. All right. I saw someone, number 69. Did you raise your card or?
Yeah.
I'm sorry, you need to stand.
Yes,
Yes, what?
I just want to know what he's being charged for. If he's being charged for something, I'll decide whether I want to be here or not.
All right. So you can have a seat. So here's the thing. Let me explain something to everyone here. My uncle served in the Vietnam War, and he went there before he was drafted because they were drafting all of the young men in Grand Cayman, Louisiana. My grandmother had to sign for him to serve his country. This country doesn't ask much of us. It doesn't even ask you to vote. You don't have to vote. They don't have the draft anymore. There could be a war, you don't have to go to a draft. The only thing your country asks of you is to serve on a jury. So whether you will be here or not is going to depend on whether or not you will be selected. And one thing I do require in this courtroom is that everyone treat everyone with respect. So number 69, you will be here if you are selected. So you don't get to decide whether you will be here or not. All right, so the other thing I want to talk to you about is everyone has the right to remain silent. Does everyone remember hearing that on the television shows?
Yes.
So you don't have to testify against yourself. You can't be called as a witness. Does everyone understand?
Yes.
And hopefully some of the people here remember Matlock, Barnaby Jones. I can always tell my age groups. I remember all those cases. So is there anyone here who will hold it against Mr. Salinas if he decides not to testify? Now, the other thing is in the United States, when someone is brought for a jury trial, they're presumed to be innocent. Does everybody understand that?
Yes.
And the state has the burden to prove them guilty. So a lot of people say, it's guilty or. All right, thank you. I'll put that on the record. All right. So when you're thinking about presumption of innocence, what that really means is this. Everyone who is charged with any type of crime in the United States, they're presumed to be innocent. And the state has the burden to prove them guilty. So they have the burden to prove every element beyond a reasonable doubt. That burden never shifts to the defense. Does everybody understand?
Yes.
So the defense does not have to prove anything. Does everyone understand?
Yes.
Now let's talk about burden of proof. When I was in law school and I graduated, we had to memorize what proof beyond a reasonable doubt was. Had to know it backwards and forwards. And it seemed very complicated at the time. You had to make sure you had every comma and semicolon down. I learned that. The first jury trial I ever had in 1997, I used that definition. And then guess what? After that first trial, there is no longer a definition for proof beyond a reasonable doubt. I still remember it, but there's no definition. So when the state and the defense talk to you, they'll usually talk to you about burdens of proof by telling you what it's not. And when I was a defense attorney and a prosecutor, I would tell people what it's not. So it's not preponderance of the evidence, it's higher than that. It's not clear and convincing evidence. Clear and convincing evidence is what is used on the civil side, which is the courthouse with the green rooftop. That's what's used to determine whether or not someone's parental rights should be terminated. The highest burden of proof here in Texas is proof beyond a reasonable doubt. Does everyone understand?
Yes.
And everyone understand there is no definition. Now, I want to talk to you about the phases of a trial. The first phase of a trial in Texas is really guilty, not guilty. Does everybody understand?
Yes.
All right, at that phase of the trial, jurors or either a judge will determine whether someone's guilty or not guilty. If it's determined by a jury or a judge that someone is not guilty, then there's no second phase of a trial. However, if a person is determined to be guilty, then there's what's called a second phase in Texas, and that's called the punishment phase. And the punishment phase is where a jury or either the court makes a decision on what punishment someone should receive after they're found guilty. Does everyone understand? So the first phase of a trial is always determining whether someone is guilty or not guilty. Now, anyone who's charged with a criminal case in Texas, they have to make a decision on whether or not they will go to the court, which is the judge, or a jury for punishment. The law requires them to make a selection. So they're not making the selection saying, I'm guilty. They're making a selection because the law requires that of them. Does everyone understand?
Yes.
In this case, if he were to be found guilty, Mr. Salinas is saying that he is going to the jury for punishment. Does everyone understand?
Yes.
Is there anyone here who is not able to decide punishment? And when I say that, this is what I mean. I don't mean it's difficult. Oh my gosh, it would be so hard. I wish I wasn't here. I wish I was on a civil case. That's what I mean. That's not what I mean. What I mean is your psyche is going to be so damaged because you can't decide punishment. Is there anyone here who cannot decide punishment in any type of criminal case? Okay. The other thing I want to talk to you about is what's called the one witness rule. I'm going to give you a hypothetical. Do not add any other scenarios to this hypothetical. This is the hypothetical. There's nothing extra to add. So don't add, oh my gosh, is it light outside? Is it dark outside? This is the complete hypothetical. All right. Here we go. An offense is committed. The state calls a witness. They call one witness. You believe that witness. You don't have an issue with that witness's credibility. You know they're telling the truth. That witness proves the state's case beyond a reasonable doubt. Is everybody with me on the hypothetical? So there's no, was it dark outside? Did a cat cross the road? No. There's no, was that person attention focused? You believe that person is telling the truth. And that one person proves the state's case beyond a reasonable doubt. Is there anyone here who would still say, yeah, they proved that case beyond a reasonable doubt, but I want more witnesses? Is there anyone who feels that way? What's your number? Number 12 and 51. And 63. All right. The other question I'm going to ask, and I'm asking this question because it's come up when I've selected jurors before as a defense attorney or prosecutor, and it's come up as a judge. I think people who speak more than one language is beautiful. French is my other language. Haven't used it much in San Antonio, only used it in Louisiana. But is there anyone here who, one, English is not your first language, and two, you've had difficulty following what I've been saying? All right. Now, the other thing I want to ask you about is travel arrangements. Is there anyone here who has some time constraint? For example, you're going on a trip. It's non-refundable tickets. You can't transfer it to me. Is there anything like that out there? Number 39. All right, just 1 second. We're going to go in order. Number 3, what is your time constraint?
In June.
June? All right. Number 27.
I have doctor's appointments coming up in the next few weeks.
All right, do you have any doctor's appointment this week?
This week, no.
All right, thank you. Number 33.
This weekend.
All right, what are you doing this weekend? All right. Oh, okay. Well, what are you planning on doing there?
Fishing, taking kids to the beach.
All right, awesome. All right, thank you. Okay, and if everyone could make sure you keep your voice up, trust me, if you talk loudly, no one's gonna hold it against you. Number 35.
Mom's just saying that she has two appointments
Tomorrow?
tomorrow and Thursday.
All right, I hope she's doing okay. Thank you. All right, number 39.
I'm my mom's primary caregiver, and she has an appointment tomorrow, and I also have a trip in.
All right.
I cannot understand her, Your Honor.
All right, could you speak up for me, please?
I'm my mom's primary caregiver, and she has an appointment tomorrow, and then I have a trip on June,
Where are you going in June?
Colorado.
Oh my gosh, well, that's nice. All right, well, I hope you have good times in Colorado. Thank you. Number 41.
I'm going to Houston on Sunday. Way back on Wednesday.
Okay, Houston on Sunday. What are you doing in Houston?
Vacation.
Okay, enjoy. Number 43.
I have a trip in June,
Where are you going?
Florida.
What are you planning on doing in Florida? Okay. No, that's awesome. Thank you. You know, I'm always interested in where people are traveling. Maybe I can put that on my list of places to see. All right. Why is 44 on the same row as 47?
I don't know.
Okay, all right, thank you. Because I see 47, it seems like one is ahead and one is back. All right, juror number 44.
Yes, I have a follow-up eye appointment after surgery this Friday.
All right, that's this Friday.
Yes, ma'am.
All right, what surgery did you have?
Cataract surgery on both eyes.
My mom did too. She said she sees better now.
Yeah, you do, but I have another disease that dries them up.
Ah, how many fingers am I holding up?
Two.
Yes, see, your vision is so much better than mine.
I can't see those now.
All right, awesome. Thank you.
Thank you very much.
Yeah. Number 47.
I'll be on vacation May 28th through June 5th.
All right, and where are you going?
New Orleans, and then I'm gonna drive to Florida.
Oh, wow. Well, enjoy. Number 58.
I'll be on vacation July the 22nd. July the 22nd, I'll be on vacation.
Oh, where are you heading?
Cancun.
Oh, well, definitely enjoy. All right, number 49.
I'm not sure if it's too late, but I'll be going to Salvador Island June 28th through the 1st.
Oh, where are you going?
It's
What's,
the beach.
oh, okay, awesome.
It's
All right,
from
then.
Texas.
I've never been. I'm gonna have to go.
It's nice.
All right, thank you. People are shocked I've never been. Number 67.
I have a scheduled surgery next Thursday.
All right, well, I know everything is gonna go well. Thank you for letting us know. Is there anyone else? Number 11?
Yeah, my wife, she needed help. We just got in an accident, obviously, maybe 2 years ago. And right now, she needs some time. I need to take her to the doctor. She got in one today, and they postponed it for tomorrow.
Okay, all right, thank you for letting me know. So her doctor's appointment is tomorrow?
Yeah, it's kind of not like a doctor appointment, it's just like they're gonna make it like I don't know, like X-ray.
Okay, all right, thank you. And then number 1?
I'm gonna be out of town from June 28th to July 12th.
All right, where are you going?
Understand her,
All right, could you speak up for us, please?
I'm gonna be out of town June 28th to July 1st. I'm gonna go to North Carolina,
All right, what are you doing in North Carolina?
visiting my dad.
Not going to visit the Tar Heels, are you?
That's actually his like.
Okay,
to you.
all right, I don't know if the Longhorns would appreciate that. All right, number 2?
I have a doctor's appointment tomorrow.
Okay,
I'm gonna have a doctor's appointment on the 27th.
and number 13?
I have doctor's appointment next week and surgery in June.
All right, thank you. I know everything is going to go well. All right, so before I turn it over to the state and the defense, I'm going to tell you all a true story. It happened to me. So I have a friend from law school, or many friends from law school. And my friend from law school does civil work. So she got called to jury duty. And she's like, Stephanie, let's meet up. We haven't seen each other forever. And of course, when we meet up, it's like we've never parted, right? So we're having lunch. Lunch is going fine. I asked her, how is jury duty coming along? And she's like, it's fantastic. I'm like, wow, never heard somebody put it that way. And I said, why are you saying it's fantastic? And she says, I'm not getting selected. I said, why do you think you're not getting selected? She's like, it's just like law school. I'm sitting in the back. I got my head down, you know, dodging questions. And so I started laughing at her uncontrollably. And she's like, what's so funny? I'm like, you're so going to get selected for that jury. And she's like, what? I said, no, it's the quiet ones who always get selected. So other than remaining quiet, the quickest way to be on this jury is to raise your card and say, please pick me. Okay? So with that being said, I'm going to turn it over to the state. And if anyone needs any break at any time, just raise your card and let us know you need a break. But when one person leaves the room, everyone must leave the room. Okay? So I'm going to turn it over to the state. State.
Thank you, Judge.
And state, you have 40 minutes.
Yes, Judge, thank you. So, looks like I had some technical malfunctions, so some people received my slides, a couple of them, so not surprised to see. So again, my name is Michael Loriano, along with my partner, Michelle Hayden, we represent the state of Texas. So, who got their their card in the mail and they bought this. Right? I have only ever once had somebody actually raise their card and they're like, oh, I was super excited. But I put this as a say, thank you for coming. You'd be surprised how many people don't show up for jury duty. But it's important for both us and the defense in order to get a trial in this case to have a judge. So this is the one time I'll be thanking you for your service during this period of time. So who knows who this is? Who knows who this is? All right. I'm going to pick on somebody over here for a second. Juror number 10. It's Willie Nelson, right? And this picture should give you a hint, but what does Willie Nelson love? Smoke, right? Anything in particular you like to smoke? Marijuana, whatever you want to call it. So is Willie Nelson necessarily going to be a good juror for a possession of marijuana case? No, right? It's fair to say that, right? He not only enjoys pot, I think he smoked pot on top of the White House. That's great. But he also just doesn't agree with our possession of marijuana laws, right? And so he says, I understand law, I just don't agree with it. I don't follow it. I don't think people should follow that law, right? So this is what I'm going to refer to a lot as the Willie rule. I need to know if you disagree with the law, and that's okay. This is the one time you get to tell a judge and argue with the judge and lawyers, and you get to win every time. We don't get to argue that. It's the best. My husband would love that. And I also need to know whether you just won't follow the law, and that's okay too. If that's truly how you believe. Does that make sense to everybody? Okay. Can I get a commitment from everybody to follow the Willie rule? Yes. Okay. So, why are we here today? We're here to pick a jury, but in order to make this jury, we have to make sure that you are a fair and impartial juror. And going back to the Willie rule, I mean, would Willie necessarily be a bad juror for a murder case? No, right? I don't have any reason to believe he disagrees with the law about murder or wouldn't follow the law about murder. And so that's one way of putting it. But also there's some other more pretty much side of the brain. You're more math people, which is clearly not me, types of brains. But I like to look at it as an equation. What's a fair and impartial juror? It means you can follow the law that the judge is going to get to you. You don't need to know the law. And after we put on our case, the judge will give you the law. So you're able to follow the law that the judge gives you, and you base your decision only on the facts of this case. So in the facts of this case, you're going to get during trial. So again, this is what makes you a fair and impartial juror. You can follow the law, and you can using that law apply the facts to the law to reach a verdict. Make sense to everybody? Does anybody have any questions about any of that? So Judge touched on this, and she kind of took some of my thunder and talked about what we're going to talk about. But proof beyond a reasonable doubt. That's the state, the burden that the state has to prove each and every criminal case by. So I can tell you what it's not in certain instances, but ultimately what beyond a reasonable doubt is an individual decision that is going to be up to you to decide. I can tell you what it's not. It's not beyond all doubt, not beyond a shadow of a doubt. It's not 100%. And again, possible doesn't always mean that it's reasonable. Is it possible that a ghost invaded the body of somebody and forced them to commit a crime? I guess maybe, right? I can't say it's impossible. Does that mean that it's reasonable? No, right? So the doubt that you have has to be a reasonable doubt. And that reasonable doubt has to apply to one of the elements of the offense, which I'm about to go over in a second. So if you have a reasonable doubt that, let's say, the one witness's shirt on the day of the offense was blue or white, I don't know. I don't know that beyond a reasonable doubt. But you still believe that the state has met every other element beyond a reasonable doubt, or every element rather beyond a reasonable doubt. That means that the state has proven its case. Does that make sense to everybody? Because if you were to know something happened, 100%, you would say, what would that make you in this case? I think I heard somebody say it. Right, number 15. A witness, right? You would have been there. You would have seen it happen. So I also like to explain beyond about and using this picture. Who here has dogs? Or a dog? All right. Out of those who've raised their cards, who's come home to a scene like this before? You're number 5 you just a second. So tell me what happened. Okay, he says you went to your room and just got the shoe that you just bought, right? Were they torn up?
Yes.
Okay. Were you there to see it happen? Do you know that the dog got it? Right? So this shows probably that goes to show you that you don't have to be there to know that it happened, right? Is it possible that you have some random, you have a doggy door and a person who has a random, I don't know, shoe fetish, that's what you want to keep your house and cheat on and left? I guess it's possible, right? Does that mean it's reasonable? No. So again, you don't have to be there to know something happened beyond a reasonable doubt. Okay. So these are the elements that the state has to prove to you beyond a reasonable doubt. On or about a certain day in Bear County, Texas, the defendant violated the condition of bond set in a family violence case concerning the safety of a victim, the victim, by committing family violence, by intentionally or knowingly committing an assault. So most of these elements are generally not contested in trial, right? The day that it happened in Bear County, Texas, not to say that it won't happen in this case. The defendant, who the defendant is, the victim is who the victim is, there's a condition of bond in place. But a lot of this boils down to is whether an assault was committed or not by somebody intentionally or knowingly committing an assault. So I'm going to talk about some of these elements. So again, we have to prove one of these two instances, intentionally or knowingly. So you were to make this jury, and 6 people said, "Oh, I believe that he intentionally committed an assault," and then the other 6 said, "Oh, I believe beyond a reasonable doubt that he knowingly committed this assault." So long as each one of the 12 that makes the jury believes one of these is met beyond a reasonable doubt, then the state has met its burden of proof. Okay, does that make sense, anybody? Okay. Does anybody have any questions about that? So intentionally or knowingly, these are the two legal definitions of these two terms. So intentionally is the conscious objective or desire to engage in the conduct that causes the result. And knowingly is aware that the conduct is reasonably certain to cause the result. I think lawyers try to make things difficult sometimes, but I think it's pretty intuitive what these things mean. So let's say, Ms. Sanford, I should know your name on top of my head, sorry. If I look at you and I throw this at you and it hits you, do you believe that I've committed that intentionally? Yes, right? It's fair to say there's some things that of the context of what happened that might prove his state of mind, right? I'm looking at you, I have this in my hand, and then I throw it at you, right? So I don't have to say, Ms. Sandoval, I'm going to throw this clicker at you and I intend to hit you with it in order for me to prove that I intentionally hit you with it, right? That makes sense to everybody? We have to look around the facts surrounding everything to prove these things, right? Knowingly just means that I know the consequence of what I'm doing, right? And that's the intended consequence. Like I'm throwing at it at you, knowing that it's going to hit you. Does that make sense? And I kind of talked about this already. How do we know somebody acted intentionally knowingly? We have to infer from the facts of the case and the words and actions of the parties. So again, looking at some other facts surrounding that particular part of the offense that we have to look at in order to determine whether it happened intentionally or knowingly. Because ultimately, like the judge talked about, the defense has a 5th Amendment right not to testify, right? So you might not get to know what he thinks, right, about what happened. And I didn't see, all the put your occupations on the card. I didn't see mind reader as anybody's occupation. So you're not expected to read his mind. Does that make sense?
Yeah.
All right, so obviously this case involves family violence, as the state has to prove that he violated a condition of bond involving set in a family violence case concerning the safety of the victim. So we're talking about family violence. So this is how our law defines family violence. It includes an act by a member of a family or household against another member of the family or household. In the state of Texas, family violence is also dating violence. They are one and the same. In fact, dating violence is defined by family violence. And then dating violence is any act that includes, dating violence includes an act other than a defensive measure to protect oneself that is committed against the victim with whom the actor has or had a dating relationship. I'd like to give you the law and then just try to break this down for you. So family, I think is pretty intuitive what it means, but as far as dating violence is concerned, if you notice it says has or has had a dating relationship. So in the state of Texas, dating violence includes people that are currently in a dating relationship and people who have been in a dating relationship. So ex-girlfriends, ex-boyfriends. Does that make sense? Does anybody have any questions about that? Why is it important for the state to prosecute family violence?
I didn't hear.
Why is it important for the state to prosecute family violence cases? Juror number 42. You can see it.
To protect the victim.
To protect the victims. Okay. Juror number 27.
So that they can be accountable for all their actions,
Okay.
whatever they say or do.
Anybody else? Juror number 35.
So it won't happen again.
So it won't happen again. Right. So part of this is we have to be concerned about the relationships between the defendant and the victim, right? Is this a situation where the victim might not have power and control to get out of a relationship? They not be able to advocate for themselves depending on the situation, right? Talking about it's just family violence, that might be children, right? That might be people who are not in equal as far as the relationship is concerned. Does that make sense to everybody? Who are typically, and this is part of the definition, victims of family violence? I'm sorry. If you have you raise your cards for me. Juror number 49, you can see it for me.
Women.
Women. Juror number 38, you can see it for me.
Much anybody that is related to you in any way.
Right? Any family member. So knowing that, where does family violence usually occur? Or typically occur? Juror number 15.
In the house.
In a house, right? Juror number 7. At home, right? That makes sense, right? It happens within the house. So part of this is, I think, juror number, who said it? Should make it stop like for happening again. Who was that? Juror number 35, right? And so part of this is stopping the cycle, potentially the cycle of violence, right? Somebody entering a relationship, being abused, and then coming back full circle. So part of the state's job, is my belief, part of the state's job is it's important because we have to start interrupting the cycle of violence. Does that make sense to everybody? And you can see how in the elements that the state has to prove to you beyond a reasonable doubt, specifically in this type of offense, you know that there's already a condition of bond set in place, right? And then there's an assault after that, right? So we see potentially a cycle on these types of cases. Does that make sense, everybody? Does anybody have any questions about that? All right, so I like to use this slide to talk about two things, right? So the defendant has rights and is protected by his rights, specifically to include rather in the Fifth Amendment, right not to testify. That applies to him, to any person who's ever accused of crime. But is it fair to say that whether you're Audrey Hepburn, so the picture on the left, or if you're the woman on the right, you might have a different history and a different life, that the law protects them equally as victims. Is there anybody who disagrees with that? That's okay. I've had people disagree. So, you know, who gets to pick who the victim is in any criminal case? Right, the person who committed the act, right? They get to pick who the victim is. The state doesn't get to go, oh, well, I'd rather have a victim with less history. You might be able to do better on the stand, who's more eloquent, right? Who might be more of a model citizen, right? We don't get to pick our victims. Only the person who's been accused of the crime, the person who committed the act. That's the only person who gets to pick the victim in the violence case. That makes sense, everybody? 351.
I'm sorry, if you could speak up.
Is it relevant for us to know what the defendant was on bond?
So right now, all I can tell you is that the law says it has to be he's on bond for a family violence case, and it's a violation of a condition of a bond that relates to the safety of the victim. Does that make sense? So I can tell you, he has to be on bond for a family violence case, and then it has to be a bond condition that relates to the safety of the victim. Does that make sense? Does anybody have any questions similar to 51?
I have a question for you.
Yes, journal 61.
That
You can
is
see
a
it from
picture- That other picture, do you know who that is?
I don't. This is all, I get
know,
off.
but you're putting that picture and I think I know who she is. And just like, oh,
I randomly pulled this stuff off the internet.
yeah.
This
It
is like,
just threw me like,
this is not anybody I've ever dealt with as a victim here in San Antonio. I just go on the internet and just type in stuff until I find a picture I like. That I think illustrates what I'm trying to say. So I already talked about this witness violence cases. So I think jury number 15 and jury number 7 said family violence typically happens in the home. So who is usually around when these things occur? Juror number 33, can you see him? Other family members. Anybody else? Juror number 19.
Children.
Children. Juror number 8.
Friend of the family.
Friend of the family. Juror number 3.
I was gonna say nobody.
Nobody, right? It happened in a household where nobody else is there. It'd just be the two of them there. Does that make sense? And so kind of following up on what juror number 3 said, typically, if this happened in the household and nobody else is around, how many actual witnesses are usually able to testify? And again, you have to take into account that the defendant has a right not to testify, right? But who's usually able to? What are the number of witnesses? Juror number 28? Just the victim, right? 1, right? Because in many of our cases, we just have one person to testify what happened, because there's only one person there. Does that make sense to everybody? Does anybody have a problem with that? Juror number 7? And notice the difference? I mean, that could potentially come in. Is that important to you? It is. He says, what about the people on outside of the home who might see them and might see a change?
Should it be after the fact? They didn't witness it happen.
They didn't witness it.
They could have just been around the murder.
Okay.
There's visible signs that there was violence, then you could take that.
Okay. So visible injuries are important. Your number 68?
I have a question.
Yes, sir.
Well, if someone saw the act being committed and there are witnesses, you witnessed something being happened,
Yes.
as opposed to if someone saw the victim or the perpetrator afterwards, they're no longer witnesses, they're just perhaps taken into consideration or thinking that something might have happened, they might have heard screams, or they might have heard something, but they're not the same.
Right. And so I think what you're trying to say is there's a distinction between people who have witnessed what happened, the actual offense itself, and there might be witnesses outside that might be able to
But I wouldn't call them witnesses. though.
Okay.
Because the word witness means that I witnessed somebody actually saw an act.
Okay.
And if I didn't see an act and I just assume or presume that something happened because I may see physical harm or I might have heard something scream, that's not a witness. I didn't witness anything.
Okay.
I made a presumption. Is
Okay.
that correct?
Well, is that how you feel? I can't tell you how you feel is correct or incorrect. right?
Well, that's how I feel.
That's how you feel. Does anybody feel similar to juror number, what's your? 68. Juror number 33, 41, 47, 46, and 74. Thank you. Guys. Yes.
What if the one witness has a motive for lying?
Well, and we're gonna talk about that in a second. We'll talk about credibility and all this, but I promise I'm gonna say that. If I don't answer your question, and so, hey, Michael, I'm gonna fill this call. So, in this situation, in this hypothetical, you have to get robbed. I'm sorry, it just is what it is. 'Cause I've had jurors before say, well, I just choose not to be robbed. Well, this is not a choice. You only get two choices. You gotta get robbed. But with the hypothetical, so you really don't have to be robbed. It's a good thing. So, who would rather be robbed in the picture on the left versus the picture on the right? That's down to you. Who would rather be robbed on the picture on your left, this empty alleyway with nobody in it, versus the picture on the right, which is Memorial City, which holds over 100,000 people. So is there anybody who'd rather be robbed on the left? Okay. Juror number 33, can you enlighten me? Right there. I'm gonna touch that one, sir. Make sure not to run into it. I definitely, even if it crossed my mind, I'm gonna do it now. All right. I see your process now. Thank you. So I think other than how 33 feels, I think generally people say, and most of the response I always get is the right? Memorial City, I'd rather have 100,000 witnesses say what happened to me, right? Probably even projected on a huge jumbo screen, right? Versus the picture on the left, which is an empty alleyway, how many witnesses are you gonna have there? None, right? So I'd rather be able, personally, as a victim, to haul 100,000 butts in here and say, hey, did you see this happen? Did you see that happen live? And so, does that make sense to everybody? Is that really how most of our criminal cases work? Here's another hypothetical. You gotta get bugged in this hypothetical. So similar, but maybe your stuff doesn't get quite stolen. So you this hypothetical, if you're leaving jury duty today, you're walking to your car back to the garage, presuming that you got to get into the garage this morning. And you're just really upset because you realize you're not going to be coming back tomorrow because you didn't make the jury. So you're really upset. I really like Michael, I really like the judge, I really like John. So I thought I was going to be able to spend some time with them, but you're upset. So you're really not paying attention to your surroundings. And then you get to the garage. And this is a big county garage, so you know none of the cameras are going to work. So you don't have that. And then as soon as you get to your car, somebody mows. Nobody around. So there's no other ways. Who thinks that case should get dismissed? And we should prosecute that case. Who doesn't think we should prosecute that case? Did you hear me? Hypotheticals, you get mugged. There's no other witnesses. Who think that case should get dismissed? We shouldn't prosecute that case. Right? You got mugged, right? It's not your fault that there's no other witnesses, that the facilities management didn't fix the stupid cameras to make sure it was on video, right? And so it just really illustrates that. So these are some, like I said, quick way of getting some answers from some of y'all because I'm not gonna be able to speak all 75 individuals. So In this question, you're gonna have to choose either number 1, number 2, number 3, and number 4. And so the question is, or the statement really is, if one person testifies, that is not enough to find someone guilty. So there's 4 choices for you. Number 1 is strongly disagree. 1 witness is enough, it's believable. 2 is disagree. I will decide based on the testimony. 3 is agree, I want more. And 4 is strongly agree, I need more. So you see the difference there between 3 and 4 is want and need. So again, the question is, if only one person testifies, that is not enough to find someone guilty. Who falls into category number 1? You raise your cards. Strongly disagree. 1 witness is enough, it's believable. I see 23, 36, 39, 40, 47, 50, 58, 68, 72, and 49. 14, is your card up? No. No. Okay. Did you fall in category number 1 by any chance?
1 or 2.
Okay. Gotta pick 1. I know. I'm being that guy. You fall in category number 1. David, did I miss anybody falling in your card? 68, 35.
No, you picked me for category number 1. I wasn't,
Oh, you weren't raising your card?
no, I just put my,
Oh.
just as Judge Marvel, so.
Okay, who falls in category number 2? Disagree. I will decide based on the testimony. 1, 2, 3. And you can put your cards down when I call it. 5, 6, 7, 10, 12, 13, 15, 16, 17, 18, 19, 22, 24, 25, 26, 27, 30, 31, 28, 32, 33, 34, 37, 38, 41, 42, 43, 44, 49, 51, 53, 54, 55, 56, 59, 60, 61, 63, 65, 66, 67, 68, 70, 71, 74, and 75. Who falls in category number 3? Agree. I want more. Let's see. 4, 8, 11, 17, 20, and 64. And who falls in category number 4? Strongly agree. I need more. Sorry. So I'm going to skip over this one. So, juror number 6. This is what we're going to talk about for a second. Determining credibility of witnesses. So if you were to make this jury, the judge is going to instruct you in the jury charge that you are to determine the credibility of the witnesses and the weight to be given in testimony. Well, it's basically way of saying you get to decide whether you believe somebody, you believe all of what they're saying, none of what they're saying, some of what they're saying, and you determine how much you believe them, right? The weight to be given their testimony. So how do we, just as regular people, determine or judge the credibility of the people who we speak with? We do this every day with our kids, spouses, co-workers, right? So what are some of the things that we look for to determine the credibility of those people? Number 15.
The consistency, their trust, and
Consistency.
repeat that last part. Those are. I just like their past history.
Anybody else? Number 16. You can stand for me.
Is this like all witnesses?
Just, I'm not saying just witnesses, just people that you talk with. How do you determine the credibility of somebody?
I genuinely believe them, but also the way they see, the way they look.
Okay. Anybody else? Another gotta be more people. 14. Body language. Okay. Number 26. You can say
Emotion.
emotion.
Yeah.
Anybody else? So some of us touched on this. Their demeanor, right? How they're acting. Motive. I didn't hear everybody talk about this, but do they have a dog in the fight? There might be a reason why they're saying what they're saying, right? Is there something that is motivating them to say something or not say something, right? Do they have an interest in the outcome of something, right? So motive might play at the heart. But what they say, because generally, does what they're saying make any sense, right? So some of our kids, right, when they talk to us, we don't believe that they're not credible, right? But what they're saying might not be the most credible, except the dinosaur was in the classroom that day, right? So just generally what they say, does that make any sense, right? Turn number 15, I believe you talked about consistency statements, right? So is there a difference in what they said and somebody else might have said? Or is there a difference in what they said before? And I'm going to touch on consistency just a little bit more. And so, right, consistency might be changed by a couple of these things, right? Points of view, their perception, time. So, I like to talk about consistency in this way. Who went to Fiesta this year? You're number 24. You're number 12. 59.
8 minutes.
Thank you, Josh. And so, if we go, I used to go to Fiesta every year. You used to always go to the Battle of Flowers Parade. So, is it fair to say it? I don't think anybody could tell you every single, just by watching the parade, every single float, what order they were in, what shoes each Duchess wore, and what each band was, and then the order, right? So we don't remember everything. And if I were to tell you right after I saw it, some of the order, and then let's say 6 months later, do you think I'm going to tell you the exact same story? Right? Does it mean that I'm lying about being there? No, right? So there's things that might change, right? Am I going to have the same version of the parade that somebody sitting on a better seat up in some stands might have, even though we were at the same parade? Yeah, right? So they might have a different point of view or perception. I went to A&M. I'm always going to look for the Aggie band every time I'm there, right? I'm not always going to be able to tell you the Longhorn band is there. I have a little bit of a bias, right? So there might be points that are more important for me that I might remember that other people might remember differently. But doesn't mean that either one of us is lying about being there, right? So consistency, I go to say this, by consistency does not always mean that somebody is lying, right? Again, you have to look at all, basically everything, to determine whether that's actually true. Does that make sense, everybody? Do you have any questions on that, or disagree with me? I love when people disagree with me. You disagree with me?
I don't necessarily disagree, but I think there's a spectrum of consistency, right? In other words, you may not remember the order and all of the numbers of what do you call the flower cards. But if your story says that there happened to be a thunderstorm during the parade, and there wasn't, and you're able to validate that it wasn't because you looked at the weather report, then there has to be a spectrum of consistency.
Right. And I would say that this consistency might mean that somebody's lying, but you have to look at all of these things to determine there's consistency. Okay. So, I would talk about evidence just for a second, since I'm being close on my time. You're going to learn in this trial that testimony is evidence, right? There's no dispute about that. So everybody repeat after me. Testimony is evidence, right? So you're to make sure, I want you to remember that, right? You're not always going to get reports, police reports. You're not always going to get exhibits. You're not always going to get pictures. You're not going to do all of those things, but you're for sure going to get testimony, right? And so testimony is evidence of the case. Does that make sense, David? What type or kind of evidence would you expect in these types of cases? Juror number 6. Pictures, okay. Juror number 9.
Bruises.
Bruises, okay. Juror number 15.
Medical records.
Medical reports. Juror number 33. Please see me. 911 calls. Juror number 28.
Police report.
Police reports, okay. Juror number 60.
Text messages.
Text messages, potentially, right? So all these things that could come up in these types of cases. Is there anybody here that would need a particular piece of evidence in order to find somebody guilty of this offense? Meaning I have to see photos, or I cannot find somebody guilty. Or I have to have medical records in order to find somebody guilty of this offense. Anybody? Juror number, I'll commit you. Juror number 8. What would you use? I'm sorry?
Michael, could you not stand right between me and?
I'm sorry.
Are the jurors?
I'm sorry.
I said, oh.
Photos? Okay. Juror number 63. You can say for me. I'm sorry?
I feel like I need both. Because if without anything else that just said, I feel like it's like he said, she said.
Does that bring our time to move forward a little bit? So let me pass this too. So if you were to make this jury and if the jury was to find him guilty, you're also going to assess punishment in this case. So this is the offense. This offense is a third-degree felony, which means that this is the possible punishment. It's a fine not to exceed $10,000. Prison term of 2 years to 10 years. Both either fine and confinement, so you could assess the fine or not. I don't care if the money doesn't go in my pocket, doesn't go to the judge, doesn't go any of this. Goes to the state. And then probation is a possibility if you were never convicted of a felony before. Does that make sense to everybody? So John might be able to spend a little bit more time on this, but I'd like to think of punishment, whether you consider something or not. I think of it like a menu. So I go on to describe this by, I'm a mama's boy. I go to, well, before the pandemic, we're still kind of in, obviously, but well before the pandemic, I used to go to Saturday lunch with my mother every day. Dating date, we would always go to China. My favorite restaurant. And so I would always get a menu. I'd always look at the menu, but I'm always going to get the exact same thing, right? I'm going to get compound chicken, no celery, extra hot peppers. So what we have to do and what we have to get from you is that you're going to have to at least open up the menu, right? As far as punishment is concerned. You might say, I'm typically going to always do this, right? But I'm at least going to consider other things, right? So I might have a predisposition for prison. I might have a predisposition for probation. But I have to at least consider something, the full range of punishment. So I have to at least consider if these shoot or change, things like that. Does that make sense to everybody? I'm not gonna be able to do a little bit more on that, but there's other, we call them punishment enhancements. And so they might or might not apply in your case. So a repeat offender means that you've been to prison once before you committed this offense. And so that raises the range of punishment up by 1 degree of offense. So that means this would be a punishment of the second degree, which means it'd be 2 to 20 years in prison. And then we have what's called a habitual offender, which means you went to prison, you got out of prison. You committed another offense, you went to prison for that offense, you got out, and then you committed this offense. So it means you've gone to the penitentiary twice before you committed this new offense. Does that make sense to everybody? Okay. Juror number, you shaking your head in the green.
How did he get out in the first place?
They would have finished their sentence.
How was that sentence that short? After the second time.
All right, so remember, guys, the rule is if you're not in the jury box on this front row, you need to stand. And I want everyone to remember that when attorneys are speaking to you, they're speaking of hypotheticals. They're not speaking about this specific case. All right, I'll give you 1 minute to finish that.
Okay. I'm just going to move on to the last final questions. And really, what I want to ask, is there anyone here for any reason that we haven't been able to talk about today that can be a fair and impartial juror on this case, knowing the particular offense, not any of the facts? Juror number 6. Okay, you rather not say that loud? Okay. All right, juror number 19.
Same here. You might rather say that.
Okay. Juror number 30. Okay, can you stand for me? Juror number 38, can you stand for me?
So, I've been involved in certain cases like this, so I'm more aware of certain things that.
Okay. Is it fair to say you've been more on the accused or the victim side of it? Accused? Do you feel like you're a good cheerleader through that process?
No.
No. Juror number 26, you can say for me.
Yeah, just a family experience.
All right, time.
Thank you everybody for your time, and look forward to seeing you this fall about that day.
Carmen, we have a break.
Yes. So everyone, we're gonna take a short break. If I can have everyone back here by 4 p.m. And so everyone, please leave the cards in your seat. And when it's 4 o'clock, just make sure you're lined up outside. Don't come into the courtroom. The deputy will get you. Everyone, please rise for the jurors. Yes. All right, everyone, please be seated. All right, so we are going to continue with the defense voir dire. But before we do that, I know Mr. Young, I just want to let you all know, sometimes you're going to see people coming in the courtroom. They'll be coming from this door, giving me paperwork or other things. I still have a docket that is happening, even though you all are in here. So those people who are coming to see me have absolutely nothing to do with this case. So don't even consider that. And if you see someone coming through that door, it's because they didn't read the sign that say that we're having jury selection, and they immediately will look in and turn back around. So with that being said, I'm going to turn it over to Mr. Young.
I can get up there.
Yes.
Oh, right. The elements of the offense. Now, as we go through this, realize this is 1 through 14 over here. Now, how many jurors do we need to have? We need to have 12 jurors, right? And the way it's done is that the prosecution and the defense each get 10 preemptory strikes. That means I can challenge somebody, or Michael or Melissa can challenge someone, Michelle, I'm sorry. Just because they don't like me. It's easy. You make a challenge, click, they're gone. They're not on it. But you notice how careful the bailiff is to have you lined up in numerical order. That's not just them being officious, that's because it's important. Those 10 strikes start out with number 1. 3, 4. Where's number 32? 32? There. If there are no challenges for cause, he is the last person that could become a member of this jury. People are really sort of an extra afterthought. They don't know which case it will get told, and it may be a case that's going to have, huge repercussions. Everybody's going to, be sick when they hear about, they're going to have to listen to the evidence. And that's why they have 75 people here. 32 is the magic number. Now, when there are challenges for cause, those are outside that system. So if there is a challenge for cause that's granted by the judge, either side can make them. If that person is challenged, and they can't be on the jury, then number 33 becomes the number. You understand how that works? And that's why everybody is seated in numerical order. So we don't get confused and we know who to focus on. All right. Elements. Each and every one of the elements of the offense is important. And each one of them is a true-false test. Now, how many people here took a true-false test sometime in their education? Hopefully everybody did. It's easy to grade, so teachers use them a lot. Anybody know what the key decision-making factor is on a true-false question? How do you decide whether it's true or false? Okay, number 15.
Facts.
What?
Facts.
Facts. Okay, that's generic. Number 27.
You analyze the question, you decipher pieces of the question,
Yeah.
and then from there you figure out whether it's true or false.
Okay, how do you decide whether it's true or false? Though?
But it depends on what the question is.
No. True, false question. Yes.
Evidence-based.
Evidence-based, all good generic questions. You gotta realize, I was a teacher at one point. Every single
word in that question has to be true for it not to be false. And that's what this is. It's a true false test. They have to prove it. Yes, beyond a reasonable doubt. But the key is that there can be no element that they have not proven. And if it is, then it's a not guilty verdict. If they prove every element, then it is a guilty verdict. That's what the judge talked to you about to begin with. Okay, beyond a reasonable doubt. We are almost a unique entity in the world in that we use citizen jurors to find whether a person is guilty or not in a criminal case. We also do it in civil cases, but the standard of proof is really high in criminal cases, and there's a reason for that. I call it the used car rule. He's got his Willie rule, and I've got my used car rule. How many people here have ever bought a used car? Almost unanimous. The lucky ones have not. How many people here were sure the next day, the next week, that they made the best deal they could on that used car? You're sneaky. Why do you think you made the best deal? Well, it's not a Ford, fix and repair daily, but
That's less electrical parts. Yeah.
it's an excellent car, and you got the best deal you could,
Yes, sir.
and you bought it from your mother. No, okay. We want to make sure, and our founding fathers want to make sure, that since we weren't using professional jurists, that you didn't carry the question in the back of your heart, did I make the right decision? So they made the standard of proof so high that you wouldn't look over your shoulder and wonder whether you made the best deal you could on that used car. That's the reason we use beyond a reasonable doubt. And no, there's no definition of it. It's what you think beyond a reasonable doubt. So what's the, as the judge said, we're going to use the opposite approach. If you have a doubt and you believe it's reasonable, can you find the person guilty beyond a reasonable doubt? I would posit no, if you have a reasonable doubt. Who decides whether it's a reasonable doubt or not? Anybody? Number 15 again, you're the only one that wants to talk. She doesn't want to get on this jury. Yeah. You, not we, you. In your heart of hearts, has it been proven to me beyond a reasonable doubt? Now, I'm going to share some of the checkered history of my family. My daughter, when she was a teenager, did something that violated, and I honestly, I say this generic because I don't even remember what it was. That was 30 years ago. Now, she violated some rule. I forget what it was, but I confronted her on it. And I said, Margaret, why did you do that? I didn't do it. She goes, "Well, I've been doing this for a very long time. Yes, I'm just as old as I was. You can't prove that I did it." Now, does anybody else besides me find that a little humorous? Yeah. I said, I don't have to prove it. I just have to believe it. And she got punished. Now, you are not in that system. This is not your daughter. It's a very structured, very formal system. We're going to ask you not to even discuss the facts of this case until the bailiffs take you to the deliberation room to deliberate, to share your collective knowledge. Yes, it's individual, but it is also a collective decision because you gotta come to it unanimously. Going to share what you remember, what things were important for you. And it's candidly, it's usually a different thing that's important for every single member of the jury. So we've got that. We've got you finding it by beyond a reasonable doubt. And then we've got a couple other little details. Number 6, Mr. Mays, yes. You mentioned, what if the person's lying and it's the one person? How would you decide that? How would you figure out whether they're lying to you? Okay. Want some help? I am going to try and give you the basis for knowing why you may not believe that. One witness, the Texas law says you can find a person guilty on one witness. Yep. Beyond a reasonable doubt. Okay. Let's see. But I have to warn you that even though our hearts will go out to you, the prosecutors and I are not going to be able to just give everybody that has something in their future a free pass on this. It's too important. We've got to have people here. San Antonio is the envy of many of the metropolitan areas because so many of our jurors show up. And it's about 50%. Can you imagine how many people they have to call in Houston to get anybody to come in for jury duty? Okay. We will look at it. We will be sympathetic, but honestly, we're gonna ultimately probably gonna come down on the side of you need to be here. And if there's a chance we can move things around, if you have something scheduled for a week or two from now, you're probably not going to pay any attention to it. People who have medical appointments they can't avoid, things that are life-threatening, then we're probably going to say, yes, you can't pay attention to what we're doing. We know you're going to be thinking about something else. But if it's off in the distance, it's just part of your life. When we look at family violence laws in Texas and in the United States, they're designed as a shield for the vulnerable people in our society. Would everybody agree with that?
Yes.
How many people here are familiar with the concept of hammering a shield into a sword? Can you imagine what that means? Using that shield as a weapon, as a sword in what may be a continuing conflict. We want you to be able to look at that and evaluate those differences. And yes, I'm not paying much attention to you. I told you why. Now, as we go through this, if somebody came to you and you believe when they finished their testimony or when all the testimony was done, that they had created family violence into a sword, would you feel like you could find that verdict? I'm confused. Now I've made a mistake. I confused somebody. I'm not supposed to confuse you. If a person is saying that they have climbed the Eiffel Tower, and you know they've never been to France, no. Would you be able to say, I don't think that's true? Yes. Okay. Would that meet your definition beyond a reasonable doubt? Absolutely. Okay. Not confused anymore. Good. See, I'm not supposed to confuse people. I'm supposed to try and straighten a few things out. Let's see. The one witness rule, the judge told you to begin with, the one witness rule meant that the state could find someone guilty, have you find them guilty beyond a reasonable doubt with one witness. But it also said, if you believe that person beyond a reasonable doubt. So they don't have to have but one witness. Yeah, that one witness has convinced you. We're not talking about something the Greek philosopher is going to twist and make you wonder what in the world happened. Talking about belief. Can you do that? Yes, you can. Number 15. We got a whole bunch of different things, possible ways to prove things in court. Many people came up with some very interesting things. Many of them are commonly used in court. They're admissible. They can be shown to you. You can take them to the jury room if they are admitted into evidence. And the judge is the gatekeeper on that. The state and the defense may offer evidence, not just witnesses, but physical things. And then the judge would decide whether they met the standard for being admissible. Any question about that? Is there anybody here who shouldn't be on this jury? Thank you, Your Honor. I'm done.
All right. So ladies and gentlemen, I'm going to have you all step outside. There are a few people that I did take notes who want to be called up individually, so we will do that. And so if you could, and I'm sorry, the gentleman in the back, what's your number? 52? All right. So if you all could step outside and everybody who's in the box, and actually everyone, if you could please take your personal items with you, but leave your cards behind. All right. So if everyone can wait outside the door, and we'll call you back in when we're ready. And juror number 3, if you could remain in the room, please.
What number is it?
Number 3. Oh, just have a seat.
Okay,
My understanding, you wanted to be called up, correct?
no, ma'am.
Oh, you did not? Oh, okay, you can go out with the rest of the group. I have the number written down.
It is getting hot in here.
I know I have no control over the thermostat.
You're
There's a
going.
fan.
Oh,
We'll take that. If you just- yeah, but
Are we gonna be outside then?
Can you let the deputy know those other jurors who need to come back in individually?
Bree said that she didn't want. I heard that too.
So the first one that's going to be called in is going to be juror number 6. So everyone can be seated. Yes, we can take up the notes, yes. Juror number 6.
Yes, ma'am.
Hi, it's the court's understanding that there was something that you wanted to discuss outside the presence of the,
No, ma'am.
oh, there's nothing you wanted to discuss?
No, I just didn't want to say anything out loud. I didn't have anything to discuss with you.
Oh, what did you want to say though?
Oh, nothing.
All right, do y'all have any questions for number 6?
Yes, when we were talking about can't be fair and impartial, you said that you didn't want to say in front of the entire panel. That's right. Okay. And
So that's what they want to talk to you about.
okay.
So what do you mean you can't be fair and impartial?
I just don't want to discuss it with anybody.
Oh, not even with the court?
Right.
Right, so here's the thing. You're gonna have to discuss it with the court.
I'm going to have to.
Yes. So that the state and the defense can make appropriate decisions.
Okay.
And I understand that there are some things we want to keep to ourselves, but I can't say, no, you can't share that, because then the state and the defense will not know whether or not you're a good person for this jury or not, okay?
Okay.
So what is it?
I was charged with domestic violence.
Okay,
Yeah.
all right. Any questions?
Just briefly, you think you're charged with domestic violence? Did you feel like you were? We still gotta.
Yes, well, let me ask you. So you said that you've been previously charged?
Yes.
All right. Does that charge mean that you cannot be fair in this case to either the state or the defense?
Yes.
All right. And who would that be against?
State.
All right. Defense, do you have any questions?
Who, I'm assuming you were accused of family violence?
Yes, you can answer.
That's correct.
Okay, is the case still outstanding?
No.
How long ago was it?
2006.
Were you punished for it?
Yes.
Do you feel like you were treated fairly?
No.
No other questions, Your Honor?
All right. Thank you so much for sharing that with us. I appreciate it.
Thank you.
Right. State,
Yes, state would challenge for cause.
defense.
No objection.
All right, number 6, then state's cause is granted. Could I also see juror number 19? All right, juror number 19, if you could come up for me, please. Hello. Hello. Hi. My understanding, there was something that you wanted to discuss, but not in front of the entire panel.
That's correct.
Can you tell the court what that is?
I've been a victim of family violence, and I feel that even tonight, I feel like just a sense of just a reoccurrence. I mean, although it happened back in 2012, it's still, I feel that.
Does anyone wish to ask a question?
No.
Defense?
Ma'am, do you feel like you would not be fair to one side or the other?
That's correct.
Why? Yes, I know you said that you were a victim, and I understand that. Why do you think that you would not be able to be fair?
Because I guess I would be more of the juror to be, like I would say, yes, convict them of, even though I guess I would just see or hear what the victim says, and then I would probably have a different it'll last right here.
But you don't think you could be fair to the defense because of your experience?
That's correct. That's what I'm trying to say. Yes, sir.
All right, thank you so
No
much.
further questions.
Thank you.
You have beautiful earrings, by the way.
Thank you.
Okay. Okay, any objections to the defense? This challenge?
No objections.
All right, then. Excuse. Could we bring in juror number 30, please?
I had 26 and 27 also. 27 just said they wanted to be called up about something when everyone was going out. And 26, I think, said they had a family experience that they didn't want to talk about.
You say 26 again?
26 and 27.
All right. Juror number 30, if you can come forward, please.
Excuse me.
Oh, no problem. Here.
I've been suppressing.
That's okay. By your tears, I'm assuming that you won't be able to sit on this type of jury.
No, definitely not.
Okay, I hate to do this to you, but I have to ask, is there a reason that you feel unfair to one side or the other?
Yeah, I literally, from the first 5 minutes, just felt like I was gonna go into a full-on panic attack.
Thank you for coming.
Thank you.
Did you want to ask a question?
We challenge it for cause.
All right. All right, any objection to 30 for cause? All right, could I see juror number 26, please?
She did a better job than 69.
Sorry.
Juror number 30, if she wants to maybe wait in the
Okay,
side room, she can wait in the side room to compose. All right, you're juror number 26?
Yes.
All right, it's my understanding that you had something that maybe you wanted to discuss not in front of everyone.
Oh, just that I've had a personal experience in a family. My sister who was part of a domestic case and was assaulted and years of in and out of prison, the father of her kids. But we were all affected by it in many ways.
All right, defense, do you have any questions?
And would that impact on your ability to be fair and impartial in this case?
I think, yeah. It's close to the surface, sorry. My sister since passed away, but thanks. But yeah, unfortunately, that would be really hard for me.
And how long ago was this?
It's the first time was 21 years ago, and then the last time, so over the last 20 years, and she passed away 3 years ago. So, yeah.
Okay, no further questions.
Thanks.
All right, thank you so much.
Challenge for cause.
All right, if you could bring in number 27, please.
Hello. Hi. Okay, I just found out that I have a doctor's appointment Thursday.
Okay.
So this is I just wanted you to know because I just found out myself.
All
I
right.
forgot about it.
All right, so what we'll do is we'll put that down
Okay.
so that both parties know. Thank you for letting us know.
Okay.
All right,
Thank
thank
you.
you. And can we see juror number 52? All right, juror number 52, you had something you wanted to discuss with us?
Yes, ma'am.
Yes.
I'm a retired policeman with the city. I was 22 years with them. I arrested many people for family violence, cases such like this. Saw both sides of it, and also my personal life. My son's been arrested for family violence also, and had a bond revocation exactly like this. So.
All right,
I
so
saw
that's what
both
you want
sides
to
of
let
it.
us know?
Yes, ma'am.
All right, is there, well, thank you for letting us know.
Thank you.
All right. All right. So everyone, these are the jurors who are no longer on the list. Number 6, can you have Lupe come out, or whoever's going to be doing this? Yes. Number 6 is state's cause. Number 9 was agreed excused.
Number what?
Number 9, it was agreed that they were excused.
Oh.
That's the person who is ill.
Okay.
Number 19, defense's cause. Number 21, that was one of the jurors who did not show. Is that correct, both sides?
Yes.
And we are opposed to that.
Yes. Court understands, court is overruling. Number 26, defendant's cause. Number 30, defendant's cause. Number 45, that was a juror no-show. And number 73 is a juror no-show.
And we are opposed to going forward without those juries showing.
All right, that would be overruled.
And Judge, we had just, I believe, 2 other challenges for cause based on, at least 2 other challenges for cause based on their, what was elicited from the state court and defendants.
Okay, which jurors?
State would move to challenge juror number 8, based on the fact that he would need photos in order to find somebody guilty of this offense. Juror number 9, I'm sorry, juror number 12, based on the court's explanation of the one witness rule. Juror number 38, based on the fact that I believe she stated that she had been accused of this offense and that she was not treated fairly during this process. Juror number 51 and 63, both based on their responses to the court's instruction of the one witness rule.
All right, with regards to juror number 12, that will be granted. That witness, that juror did state that the one witness rule, that she would not abide by that.
I disagree, Your Honor.
Okay, all right, juror number 12, the state's request to strike or cause is granted. Juror number 51, defense. That juror could not follow the one witness rule. Defense, do you have any argument for number 51?
We object.
All right, state's objection to juror number 51 for cause is granted. Juror number 63, again, it involves the one witness rule. And the state is requesting that that juror be struck for cause. Any objection, defense?
Yes.
All right, that will be state's strike for cause on juror number 63 will be granted. State strike for cause on juror number 8 will be denied. And juror number state's request for strike for cause on jury number 38 will be denied. All right, the other issue is the jurors who have doctor's appointments. So juror number 2 says that they have a doctor's appointment tomorrow.
I
And we
guess
do
I
know
would,
that this,
I would like to see what the doctor's appointment is about. Is it that they're supposed to go in and have their eyes checked, as opposed to the lady that had, cataract surgery and has to have a follow-up.
Yeah, what I can tell you is the jurors that the court notated are not jurors who have appointments in the future. And when I say in the future, not next week. So this is what the court has. Juror number 2 has a doctor's appointment tomorrow. Juror number 11 has a doctor's appointment tomorrow. Juror number 35 has a doctor's appointment with their mother tomorrow. Juror number 39 is their mother's primary care person. Juror number 44 has an appointment on Friday, which we may not go to Friday, but just so you all know. And juror number 27 has a doctor's appointment this week. So with regards to juror number 2, are you all going to agree to juror number 2 or no?
They would agree.
Defense?
Yes,
That's agreed. Juror number 11 has a doctor's appointment tomorrow. Is that agreed or no?
They would agree.
agreed.
Juror number 35 has a doctor's appointment with their mom this week.
Do not agree.
All right. Juror number 39 has a doctor's, is their mom's primary care.
Do not agree.
Okay. And yes,
Juror number 27, I believe we skipped over. She's the one who came in.
yes, I'm about to.
I'm sorry.
No problem, no problem. And juror number 27 has a doctor's appointment on Thursday.
Agreed.
Hmm?
Agreed.
All right. All right, so Caroline, these are the ones that are agreed to, and number 2 is agreed to. Number 6 is state cause. Number 9 has been excused. Well, it's an agreed, number 9. Number 11 is agreed. Number 12 is state's cause. Number 19 is defense's cause. Number 21, they're excused by the court. They're a no-show. Number 26, defense cause. Number 27 is agreed. Number 30 is defense's cause. Number 45, that's a no-show, and that person is excused. Number 51, state's cause. Number 63, state's cause. Number 73 is a no-show.
Wait, can you go back just a step? After 51, what did you call?
Let me see. After 51, I have 63 as a state's cause.
63, okay.
Yes. All right. So does everyone have the numbers that the court has?
Yes, Judge.
All right. So let me see where our strike zone is. So I have our strike zone is 42. Does everyone have that?
Let's-
Yes, I have, you have 42, Brenda?
I counted for you.
Thank you. I have 42 as well.
Three, 4, 5, 6, 7, 8, 9. I must be missing somebody then. Because I've got 9 challenges within that
All right, so this
zone.
I have 43.
That's 42.
is number 2. All right, John, Number
Okay,
6.
yes.
6,
6.
9.
That's the one I didn't,
All right,
there, now I have 10.
all right. So the strike zone is 42, and then this one second. And then 47, you all will have an alternate from 43, yes.
I neglected, I believe that 46 told the bailiffs and or Rebecca that they had was a language issue.
Yes, John, I'm sorry, juror number 46 doesn't understand English.
We have to bring him in because that's,
All right,
you
all right.
asked that question and
No.
nobody answered.
All right, deputies, could I have juror number 46 brought in, please? Sorry. Oh, no problem.
Working on my notes.
All right, juror number 46, if you can come forward, please. All right, juror number 46, what is your first language?
Español, Spanish.
Have you been able to understand everything?
Not all of it.
So were you able to understand everything that I was talking about or no?
Those, sí, poquitos, yes, a little.
State, do you have any questions?
No, Judge.
Defense.
Have you understood the questions of the prosecution and I had asked during the questioning period?
No todo, not all of it.
Okay.
No. Bueno,
No habla español, se necesita.
cuando a él casi no lo entendí mucho.
She said that she hardly understood.
Okay,
A
I'm sorry.
él,
wait, here's
with
the-
him,
Just 1 second. So,
sí.
The court reporter, she has to take down what's being said.
Okay,
Okay.
sorry.
That's okay. The court reporter is right there. So
Oh,
have you been, that's okay. It happens.
I'm
Have you been
sorry.
able to understand everything that the state and the defense and myself have been saying?
Not all of it, to be honest.
Have you been able to understand all of the concepts? And when I say concepts, I mean the legal.
Poco, a little.
Hello.
Uh-huh.
All right, defense, do you have any questions?
No, Your Honor.
All right, thank you.
I'm sorry.
Gracias, that's all I
Thank you,
know.
ma'am.
Okay, I'm working on it. With regards to juror number 46.
Challenge for cause.
They would also challenge your cause.
All right, so it's agreed. Number 46 is agreed to. So your strike zone is up to 42, and you each will have 1 extra strike to be used.
It was, oh yeah, she's after 42.
Yes.
Never mind.
No problem. And you each will have 1 additional strike to use between 43 and 46. Let me make sure that's correct.
43 and 40 what?
47.
Not 46.
I'm sorry, 43 and 48. You will each receive 1 additional strike. So that we can have an alternate, 2 alternates.
We'll be back.
Thank you.
Jury?
And if you can mute us, please. So these are the persons who will be on the jury panel. Number 3, 5, 14, 22, 23, 24, 28, 31, 32, 33, 34, and 35. The alternates are 47 and 48. Is there any objection? State.
No, Your Honor.
Defense.
No objection, Your Honor.
All right, if we could bring the panel in, please.
This is way at the end of the end, so everything, sit in, just move on with the end, there's no more numbers. Just sit anywhere, as long as you go all the way. All the way to the end, all the way. There's space up here that first bench too. All the way to the
Yes,
end.
everyone, you can sit wherever you would like to sit. And the pieces of paper that are there, only take one.
There's always. Yes, yes, it's just that. Since you sit on this end, yes. There's room up here in the front. And there's 2 chairs up here. Not everybody's gonna get a space. No. Not right now. But there's 2 chairs, there's a chair right there. And there's another chair. Not everybody's gonna get a seat. Some people will be standing, so come on forward, don't be shy. Up to here. So we can do this 14.
All right, everyone, please be seated. All right, ladies and gentlemen, I want to thank you so much for your service. As I stated previously, your country doesn't ask much of you. They don't ask you to vote. You're no longer drafted into military service, but one of the things they do ask of you is to appear for jury duty. We cannot have jury trials if we don't have jurors. So thank you for coming down. As I call your name, I'm going to need you to take a seat in the jury box. You will be on this jury panel. Juror number 3, Jessica Bobadilla. Number 5, Michelle Dominguez. Number 14, Isabel Kianis. Number 22, Aaron Hernandez. Number 23, Caitlin Mariquin. Number 24, Virginia Sandoval. Number 28, Norma Llamas. Number 31, Devin Hosey. Number 32, Joseph Carlson. Number 33, Clayton Hebner. Number 34, Valeria Contreras. Number 35, Alfredo Garza. Number 47, Kimberly Lawson. Number 48, Alberto Rivera.
That's what I'm laughing.
All right, so those of you who are remaining in the audience, what you have in your hand is a sheet of paper. You can do one or two things. You can donate the paper. Yes. Do you not have the paper? All right, we'll make sure you get one. All right, the deputy has extra if you need one towards the back or if you didn't receive one. So your service here today, you do receive payment for your service here today. Of course, it's never enough. It doesn't replace the amount maybe you would have made if you were at work. But again, your service is needed for us to have jury trials. You can do one or two things. You can go downstairs and you can donate what you receive in payment to many of the organizations that's listed downstairs, or you can not donate it. If you don't donate it, probably 2 months from now or 3 months from now, you're going to forget about the great time that you had in the 187. And you're going to say, wow, I have a check. What is this for? And I guarantee you that will be enough for you to have a great lunch and just enjoy your day. So thank you all again for coming. The courtroom is open to the public. So I don't want the process of how juries are selected and what happens at the courthouse to be a mystery to people. So you're more than welcome to come down and visit the 187th District Court at any time. With that, I'm going to let you all go. Thank you. Bye-bye.
Yeah.
Is there something you needed
Is there any way I can speak to that gentleman?
concerning?
The video, the pictures?
Oh, I'm sorry. You'll have to wait till after I give them instructions. Then of course you can wait. All right, everyone, please be seated. All right, so you all are all on the jury panel. I'm going to give you some instructions. First of all, as you can tell, I have no control over the temperature in this courtroom. Sometimes it is very hot, sometimes it is very cold, sometimes it switches from hot to cold immediately. So be sure to bring a jacket. If you would like to bring anything to drink, you're more than welcome to do so. Just make sure that it has a cap on it so that if it spills, it won't spill on the carpet. The other thing, we will start tomorrow at 9 a.m., but we cannot start unless all of you are here at 9 a.m. When you come to report tomorrow, you will not report inside this courtroom. Deputy Laura will show you where you need to go. All right? Any questions so far? Yes.
So my employer requires proof like for every day that I'm out, like it's something every day?
Yes, we will make sure that you have that. And for everyone, if there is an issue, you can always have your employer call the court and we will let them know that you are here. So please don't be concerned about that. We'll take care of that. The other thing, I usually try to make sure that we are out of court before rush hour traffic. Rush hour traffic here is at 5 o'clock. So you all should be thanking me today because I think we're going to beat it because it's going to be 5:30. But usually we do recess at 4:30. The only reason why we won't recess at 4:30, if for instance, we're in the middle of a witness, I don't like for us to leave in the middle of testimony. My understanding from both sides is I don't think there's an anticipation that this will go into next week. So this, it's anticipated that the trial will probably end this week. All right. Any other questions? Yes, no problem.
In the Zoom, they said that we could bring lunch. That's okay.
Yes, everyone, you are more than welcome to bring lunch, bring snacks, bring anything else that you need. The other thing, if anyone ever needs a break during testimony, or if you just need a break, just raise your hand. If I don't see you, I guarantee you the state defense or the deputies will see you, or Brenna, who has eyes in the back of her head. She'll be able to see you. So don't hesitate to raise your hand for that. If witnesses are testifying or if there's something that you can't hear, be sure and raise your hand and let us know. I'm sure both the state and the defense would appreciate that if you are not able to hear anything. I'm sorry, you had a question?
Am I gonna have to make a decision on something?
Yes, you are.
Yeah, it's not gonna happen.
Yeah, it is. So
No,
here's the,
I'd rather just be quiet than make any kind of decision.
here's the thing. You're on the panel and you're gonna have to listen
Okay.
to the witnesses that are called. You understand?
I understand that.
All right, thank you. So is there anything else? All right. Any other questions? All right, so we're going to start tomorrow at 9 a.m. It is very important that everyone is here at 9 a.m. It's usually very crowded. It's usually sometimes hard to find parking space. So you probably want to get downtown before 9 in order to make it here. And I would say usually the best thing to do is by 8:30, there's usually parking space to be found. And as you all can tell from when you came down here, there's a lot of construction. So hopefully everybody knows where all of the construction is. Okay, anything else?
Do you intend to swear that you're on your own?
No. Okay. Is there anything else from either? Any other questions? All right, then I will see you all here tomorrow at 9 a.m. All right, everyone, please rise.